Good dear students, and I hope that you all are well. In the last class, we looked at the introductory part of the remedies. We looked at significance of remedies, and then we looked at types of remedies under the contract. And under the types, we looked at specific performance. We looked at liquidated damages. Then we looked at unliquidated damages, and we also under the unliquidated damages we studied three components. We studied about compensated damages, then we looked at the reliance interest, we also looked at expectancy interest, and in today's class we are going to continue with the types of damages and the various concepts related to damages. And the first we have is the mitigation or obligation on the third party, on the non-breaching party. So basically, this is an obligation on the non-breaching party. So this is a defense, and you could say this is a defense for the defendant or who has breached the party. You could use this as a means of trying to mitigate the consequences in terms of damages. So mitigation damages thus is also known as avoidable consequences. In this case, plaintiff must take reasonable steps to avoid further damages. Mitigation of damages, or the doctrine of avoidable consequence, is a doctrine of remedies that requires plaintiff to take reasonable steps to avoid making the damage the plaintiff suffered any greater than need be, so without diminishing the responsibility of the defendant. The plaintiff may neither act unreasonably to increase the damage suffered, nor avoid the reasonable steps or responsible parties would take to keep a harm from growing the worse. The mitigation is a defense, therefore, for the party and imposes obligation on the non-breaching party. So basically, that person has to take certain reasonable steps to avoid the damages. And so under the doctrine of avoidable consequences, or a plaintiff whose action or inaction aggravated the harm caused by the defendant will not receive full compensation for the harm. So the damages will be mitigated to the extent the plaintiff was at fault for the damages. So for example, in the case of Walker versus Salt Flat Water Company, the corporation in 1999. This is a very old case, 1936. So in this case, a suit by Walker against Salt Flat Water Company to recover damages for breach of contract, which water company had agreed to pay all damages resulting from its act, and for omissions in laying, maintaining, operating, replacing, changing, or removing a pipeline to be constructed across plaintiff's farm, in which contract they had also agreed to maintain all pipelines so as to not to interfere with cultivation or damage the drainage of that land. So plaintiff alleged that because of the negligence on the part of the water company, after they had laid the pipes in line, piling or banking the dirt upon the pipeline, a levee was created, and that in time of rain impounded and backed up the surface water on that land, and which, when it broke through the levee, ran across the land, causing a deep washes and gullies, and they were permanently injured the land. So defendants answered by demurrage and plea that plaintiff could have, by the use of slightest degree of care, with very little effort and expense, prevented such damages, if any, and could have reduced such damages to practically nothing. So when plaintiffs contended that their land had been damaged by the acts of defendant, and defendant contended that plaintiffs were guilty of contributory negligence in not averting the damage by themselves, providing the proper damage, and when the evidence is such that reasonable minds differ as to effect and as to the inferences and conclusions to be drawn, and therefrom the question of plaintiff arises. as a contributory negligence. So the question should was submitted to the jury, and the court instructed to thereon to come up with the solution. And the final decision of that case was that the court held that where a party is entitled to the benefits of a contract can save himself from damages resulting from its breach at trifling expenses or with reasonable exertions, it is his duty to incur such expense and make such exertions in such circumstances he can only charge party in default with such damages as he could not have prevented with reasonable exertions and expense. But where the party is in a fault was in a duty bound to prevent damages and had equal opportunity with persons injured for performance and equal knowledge of consequence of non-performance, he cannot, while the contract is in force and effect, be heard to say that plaintiff might have performed for him, thus avoided such damages. So therefore, it is not always on the part of the breaching, party to do all the obligations in terms of damages. When damages are in fact, calculated, the mitigation process is taken into consideration to fairly ensure that the damages are adequate and not beyond what is needed. So in the Contract Act of Bhutan, Section 214, under this section, the doctrine of mitigation is recognized, and this section states that when estimating the quantum of a loss or a damage, mitigating measures taken or should have taken to minimize the loss or damage by non-breaching party must be taken into consideration. So this means, you know, when non-breaching party has the right to be compensated for the loss or damage caused as a result of breach of the contract, the non-breaching party, as a party to the contract, also has the duties or obligations to take measures to avoid the loss or damage before he claims the compensation. So in short, the claimants can simply sit back and allow losses to pile up or expect the defendant to pay compensation for the whole amount if there is something they reasonably could do to reduce the loss. So in a way, the plaintiffs are under duty to mitigate their loss, and one cannot recover damages for loss which have been which can be avoided by taking reasonable steps. And contrarily, under Section 214, the party who breached the contract can assert that breach occurred as a result of non-breaching party because he failed to take any reasonable steps to avoid the breach. Now there is the concept of the quantum merit, which is provided under Section 214, says that when estimating the quantum of loss or damage, mitigating taken has to be taken into consideration. And now we are coming to a new concept known as doctrine of quantum merit, and this doctrine of quantum merit is a Latin term meaning as much as he has deserved. It is an equitable damage remedy under the common law systems to recover the reasonable value of services rendered by the non-breaching party for party who breached the contract or actual value of services performed by the non-breaching party, which is also known as unjust enrichment. So this means if the plaintiff does not recover the reasonable value of services rendered in absence of the express contract and unjustly enrich the opposing party or that defendant, so that is known as doctrine of quantum merit. The requirement of quantum merit arises when there is a situation where uh, the payment cannot be obtained under a contract, where there is no contract, or where the price has not been specified in the contract. So quantum merit is based on a restitutionary principle and is different from damages since it merely aims to pay for the performance, not to compensate for the loss. You know, so long as there is a contract between the parties under which the claimant was intended to be paid, court will order payment of reasonable sum for performance rendered, essentially the market price, or is also known as going rate. Where there is no contract, because the contract is void, the court will still be able to order a quantum merit for performance of the performance rendered, because the other party would have unjustly enriched themselves. So that is just to equate and just to make it equitable in terms of that. It looks at from that perspective. So in a way, in this quantum merit, the two other important components are unjust enrichment and restitution, which are modern designations of doctrine of quasi-contract, which is based on the equitable principle that person shall not be allowed to enrich himself unjustly at the expense of the other. So unjust enrichment, the theory of unjust enrichment is an equitable remedy, as we have already discussed, based upon the contract implied in law. So basis for unjust enrichment doctrine is that no one ought to enrich himself unjustly at the expense of another. So most significant element of this doctrine is whether the enrichment of defendant is unjust or not. That has to be determined. That is the fundamental in understanding what is unjust enrichment. And there are several potential bases for cause of action seeking restitution. For example, restitution may be awarded in lieu of breach of contract damages when the parties had an express contract but it was procured by fraud, is unenforceable, it becomes ineffective, or for some reason, or you could also say alternatively restitution may be awarded where the defendant obtained a benefit from the plaintiff by fraud, duress, conversion, or similar conduct. So under the section 215 of the Contract Act of Bhutan, this section recognizes the doctrine of quantum merit, and the this section states that the non-breaching party shall have the right, instead of claiming damages, to make claim on the basis of quantum merit, that is, for payment of reasonable sum for obligation discharged, or for value of supplies made, work done, or service rendered by him under the contract. So in this case, there has to be a contract under the section 205. If there is no contract, then it literally doesn't operate. And in a way, you could break this section 215 into the for a number of elements. So let's say there has to be a contract, and then non-breaching party performs an act or a supply for value. So that is basically we have studied as a consideration, or a work does a work, renders a service. So basically these are all considerations, and you could see the obligations are discharged for payment of a reasonable sum, so reasonable amount or a reasonable payment, and the non-breaching party is entitled to reasonable sum, no, based on the quantum merit. Based on the quantum merit. So there is no definite or fixed definition of reasonable sum. So that means it subjects to the value of the services rendered. It is subject to value of payments that is made, and that is why it may be understood as a sum of money which is in commensurate with work done, services rendered, or goods supplied under the ordinary circumstances. So for example, there is a case known as Sir Lindsay Parkinson and Company Private Limited versus Commissioners of Work in 1949. The contractor agreed to do some building work, and the price was £5 million. But the contract allowed for extra work to be ordered, and also provided that price paid should provide profit of between £150,000 to 300,000. In the event, the commissioner did order extra work, taking the cost to over £6 million. The contractor claimed for extra profit on the basis of quantum merit. The court allowed their claim, stating that Express provisions concerning the maximum profit only apply to works worth about 5 million. The court said that quantum merit based on an extra work or goods supplied will only be allowed if the defendant had the choice of accepting or rejecting the extra benefit. And the court further said that where there is a precise provision for remuneration, a quantum merit cannot usually be used to alter the price, even if the extra work is done. So if you look at from that perspective, quantum merit is based on the extra work or is based on the additional that's value of services or supplies that is provided to the breaching party. Now with this we are going to look at the punitive or exemplary damages. So punitive and exemplary damages is an important and it is one of the oldest in fact damages under the contract or in many other other laws such as torts. And so we are going to look at these punitive damages. Okay. There are a number of the terms that is used to describe what is this punitive damages. However, the two most commonly used terms are the punitive or exemplary damages. In most jurisdictions, these terms are used interchangeable, so it means actually the same thing. In addition, treble damages are also known as punitive damages nature, and these damages are awarded by statute and are three times the amount of actual damages. So there used to be a term known as treble damages under the under the common law system, and uh, there they used to charge three times the amount of the actual damages. Another term that has been used for punitive damages is a vindictive damages. When this word is used in general sense, an individual seeks to avenge a wrong. So thus it is also a proper synonym for punitive damages. So although used less frequently, terms such as added damages, vindictive damages, smart money has also been used in the past, and it's sometimes in some jurisdictions it is also known as punitory or speculative or presumptive damages. But all of these terms describe money damages awarded in excess of the amount needed to compensate plaintiff for his injuries. So basically here these are terms that is used in terms of payment of damages in terms of monetary terms. So they looked at from that perspective in excess of what is to be compensated. And as a general rule, the terms punitive damages and exemplary damages can be used, as I told you, interchangeably. And it is sometimes this is also known as the multiple damages or punitive damages are also same. So they also use as the multiple damages. And these punitive damages used to exist, as old as 2000 BC in a code, a law known as Hammurabi, doctrine or code of Hammurabi. However, courts use the language that was often imprecise, and therefore there arose a confusion as to exact nature of the punitive damages. So fundamental principles of contract damage is that the plaintiff should be put in as good position as he would have been if the defendant had not breached the contract. So that is the general principle. That is a general principle that in a contract, the idea of damages is that it will help to put the plaintiff in a good position, in his original position, or in a good position as he would have been if the defendant had not breached the contract. But this punitive damages, in fact, goes beyond the compensation, and therefore plaintiff would be placed in better position than if the contracts were performed. So virtually any breach of contract will give a rise to claim for damages, even if the plaintiff's loss is nominal or difficult to prove. So in other words, the plaintiff is entitled to receive either nominal or compensate damages for breach of claim. But punitive damage is such that it is beyond that one. This is generally true no matter how reprehensible the breach was by the defendant, including conduct that was in bad faith, willful or wanton, intentional or malice. Okay. And reason for general rule to deny punitive damages regardless of character of breach is that plaintiff should not be placed in better position than he would have been if the contract has been performed. So, in essence, the reason for having this damages concept itself in the contract is just to put him in a good position, not better position than the defendant. But this punitive damage is such that it goes beyond this one, and then it puts you know the plaintiff in a better position than if the contract would have been performed. So this basically the goal of contract of damages is to provide relief and not punish. But punitive damages are for the purpose of punishing and deterring the defendant and go beyond compensation. And therefore such awards are not available for mere breach of contract. So this is the last resort. These are the exceptional cases. That is why it is also known as exemplary damages. So in contrast, contract damages could be determined more objectively because intangible items were not considered. So damage is calculated solely under the terms of contract. They are just calculated. But however, and sometimes they go beyond. So as we have looked at, one is a vindictive. So people want to set an example out of that in some of the contracts. And there are legal commentators who say that public policy reasons for general rule that punitive damages should not be allowed for mere breach of contract, and in a market economy, the parties should be encouraged to interact for economic benefit. The argument is that while compensatory damages encourage reliance on the business agreements, threat of additional punitive damages would create uncertainty and apprehension in the marketplace, and such an award would have a chilling effect on further contractual undertakings. A corollary to this policy argument is that some breaches are economically beneficial. So looking at the market force, because contract is basically looking at the society and how it functions in terms of transactions. So for that, the punitive damages are not desired. But on the other hand, there are scholars who would say that the punitive damages are designed to punish guilty party as well as making an example of that uh, person and discouraging similar conduct by party or other parties in future. So in most jurisdictions, punitive damages are available only if the defendant is guilty of reprehensible conduct such as fraud, malice, or oppression. So punitive damages are not measured by loss to the plaintiff nor gain to the defendant, but rather by amount necessary to punish to deter. So here, the amount is such that it really doesn't look at the loss that is incurred by the plaintiff. Instead, it looks to look at that the amount is able to punish the person who has breached the contract, and then that will prevent his similar kind of actions in future. And in most jurisdictions, punitive damages are not available for breach of contract in general. They are generally given to law of torts or related things. Since punitive measures are provided to punish a party breaching the contract or set an example for others to mean to deter not to commit similar breach by other parties in various contracts, it is also known as damages, or exemplary damages. Now, under the Section 211, Part 2 of the Contract Act of Bhutan, punitive damage is recognized, and under this section, it allows the punitive damages as long as punitive damages are justified under in the circumstances of the case based on the relevant factor, which includes conduct of party or behavior of party who breached the contract. So basically under the Bhutanese Contract Act, the punitive damages are very very wide and broad because it can be uh, applied in every case, as long as court finds that it is justified under that circumstance of the case. No? And if you look at from that perspective, in fact, the punitive damages, origin of punitive damages in the Contract Act of Bhutan. Uh, Before 2013 Act, the Contract Act of Bhutan was enacted. The breach of contract remained under the penal offence under the Penal Code of Bhutan. The penalty was not really heavy, but the breach of contract remained a criminal offence since the enactment of Penal Code in 2004. So interestingly, one would also observe in any traditional or older agreements drafted, in particular in Bhutan, the private agreements contain punitive clauses as a standard clause in every agreement, which can be loosely translated as, you could say that if any party breach this agreement, party shall be liable for imprisonment of 3 months and fine of Newton 500, and in some cases 6 months imprisonment, which later written as imprisonment as per the prevailing law. Now, even today, it says that the person can be penalized in accordance with available prevailing laws. So that means the punitive damage has always remained in our. But interestingly, the punitive damages in our contract, traditional agreement, were in fact fixed. The amount was fixed, and even the imprisonment length was fixed. And during my some of my interviews with some of the judges, the old or former judges, they did say that they used to levy the at least a fine, although if they did not imprison most of the people, but they did levy the fine of Newton 500 in case of breach of contract, even to start the litigation or even to start adjudication of that case. So in order to seek punitive damages in Bhutan is very wide under this section. This section in fact allows as long as punitive damages are justified under the circumstances of the case, no, based on relevant factors, which includes conduct of party or party who has breached the contract. So if he has a bad character, he could still apply this kind of punitive damages. Now, if you look at the remedies for third party, so first, who is a third party? Third party is a person who is neither a promisor nor a promisee in a contractual agreement, but stands out to benefit from the contract's performance. A third party beneficiary may legally enforce that contract, but only after his or her rights have already been vested, or either by contracting parties' assent or by justifiable reliance under the promise. So we have looked at a number of special contracts under similar circumstances. A minor who is be less than 18 years old, you could still have a contract in his in the for the benefit of that person. So this is a deviation from a concept that we study in the contract in the beginning, known as doctrine of privity of contract. So doctrine of privity of contract, if you recollect correctly, it means that only those who are involved in striking a bargain would have standing to enforce it. Only those who were parties to the contract could in fact enforce those contracts. So that is a general. That is in general this is still the case. Only parties to contract may sue for breach of contract. Although in recent years the rule of privity has eroded somewhat, and third-party beneficiaries have been allowed to recover damages for breach of contract they were not party to. There are two terms where third-party beneficiaries are allowed to fall under the contract in general and under the common law system. The duty owed test looks to see if the third party was agreeing to pay a debt for the original party. The intent to benefit test looks to see if circumstances indicate that promisee intends to give the beneficiary the benefit of promise performance. Any defense allowed to party of the original contracts extend to the third party beneficiaries. So a person who is basically neither a promise in the contractual but stands out to benefit from the contractual's benefit. Now, under Section 212 of the Contract Act of Bhutan states that a person who is not a party to the contract but is a beneficiary under the contract shall have the same rights as non-breaching party under that contract in respect of any loss or damage suffered by such beneficiary by reason of breach of contract. So with this section, third party to contracts in Bhutan have the right to claim compensatory damages, whether expectancy, reliance, or any kind of remedies that is provided to the you know non-breaching party. And in to understand this one of the important concepts under this is the if it is not remote, the it should not be a remote case in terms of that. So looking at the closeness of the contract under this section, and one of the important concepts is the doctrine of remoteness. And the term remoteness refers to legal test of causation, which is used when determining the types of loss caused by breach of contract or duty which may be compensated by damages or award. So legal causation is different from factual causation, which raises the question whether the damage resulted from breach of contract or duty. So accordingly, once the factual causation is established, then it is necessary to ask whether the law is prepared to attribute the damage to particular breach, you know, or damage which is too remote is not recoverable, even if there is a factual link between breach of contract or a duty and the loss. As we recollect, the concept of remoteness in the common law was first laid down under the case of Headley versus Baxendale. In this case, where the court laid down two situations: the loss which would arise naturally according to the usual course of things from the breach, and loss as may reasonably be supposed to have been in contemplation of you know, parties at the time when they made the contract as probable cause of breach of it. So this means in case of loss arising naturally during the usual course of things, the party breaching the contract is liable. But on these two tests that is laid down, the Lord and Alderson had some reservations, and he said that if special circumstances under which the contract was actually made were communicated by plaintiff to the defendant, thus known to both parties, the damages resulting from breach of such a contract which they would reasonably contemplate would be amount of injury which would ordinarily follow from the breach of contract under these special circumstances, so known and communicated. But on the other hand, he said that if these special circumstances were wholly unknown to the party breaking the contract, he at most would only be supposed to have had in his contemplation the amount of injury which would arise generally, and in the great multitude of cases not affected by any special circumstances from such a breach of contract. For had the special circumstances been known, the parties might have specially provided for breach of contract by special terms as to damages in that case, and for his disadvantage too would be very unjust to deprive them. So, looking at that perspective, he had some reservations on in this context. So, as we said, under the section 212 of the Contract Act of Bhutan, the person who is not a party to the contract but is a beneficiary under the contract have the same right as non-breaching party, and damages suffered beneficiary reason by breach of the contract. But the important concept in that party is that we have to have in fact, the concept of remoteness of the damages. If it's too remote, then the third party is not entitled. Now we are coming to the end of law of remedies. In general, we are just looking at the basic and the most general remedies that is available under the Contract Act. As we have seen that the contract remedies are not unlimited, but it's always limited. Even if you say unliquidated, there is still a limit because there is a quantum merit. There is a limitation on each of looking at the facts and circumstances. So contract remedies are never unlimited. And this one of the major reasons in Bhutan's Contract Act in terms of limitation of remedies is that it is based on a concept known as the doctrine of laches. So, under the Bhutanese Contract Act, they have provided one limitation, a major limitation in all contract breaches, and under that, it is based on the doctrine of laches. So, doctrine of laches is also an equitable law remedy under the common law system. So, in a way, you could say that as opposed to most some other laws, Contract Act of Bhutan is far more related and closer to common law system than civil law system. We already looked at various factors in civil law system, but if you look at from that perspective, we are far more closer to common law system. And doctrine of laches is one of the equitable remedies that is provided under the common law system. And the concept is based on that equity aids the vigilant, not the ones who sleep over that right. So doctrine of laches says that you should not sleep over your right. If you sleep over your right, then your right, you will have no remedy under that. No. This means law will only be able to help who remains alert or aware about their rights, and not those people who does not bother about their rights or sleep upon their rights. So if you look at from that perspective, laches is a defense developed by courts of equity, and its principal application was and remains to be the claims of an equitable cast for which the legislature has provided no fixed timeline limitation. Laches is an equitable principle that bars relief to a party whose unreasonable delay in bringing an action to for the relief prejudices the rights of other party. So laches is also an equitable doctrine which penalizes knowing inaction by party. So if you don't in fact be active on your right, this doctrine of laches would automatically punish you in a way that will bar you from getting any kind of remedies. And so therefore, laches is an equitable doctrine applied to prevent one who has not been diligent in asserting known right from recovering the expenses. If you know that you have certain rights, you must act in that field. And it is said that when a person invokes defense, that opponent had slept over his or her right, have approached the court after a long delay. Court checks into reason for delay of appointment, opponent in invoking his rights. So failure to assert one's right in timely manner can result in claims being barred by the laches. Laches is a form of estoppel. So basically it stops the person, from claiming his rights, asserting his rights. The burden of putting the defense of laches is on the person who is responding to the claims to which it applies. The laches alleges prejudicial delay and unfairness in the context of a particular situation. Therefore, non-breaching party wants to exercise his rights, he must exercise without unreasonable delay. Although the unreasonable delay is not defined, it also depends on circumstances. For example, if we have the COVID-19 case now, and if this case goes on and then courts remain closed, or he's not able to come to the court because of these restrictions imposed by the government for next 5 years, if he comes, that they will take into consideration of that to whether to provide that or not. Okay, so this is not automatically just because 3 years gone and then you are waived of that, or 5 years gone you are waived of that. It is not that. Therefore, non-breaching party wants to exercise, so he has to be, in a way, make sure that he's alert all the time. And doctrine of laches or delay will not work against them, meaning the party teaches the breaching the contract will have the defense of unreasonable doctrine to protect them, and non-breaching party will not be able to claim his right or ask the remedies for breach of contract under its contract law. So this is completely a new concept in Bhutan's contract law, and currently there are no case laws where this provision has been invoked. So in nutshell, uh, Section 220 of the Contract Act says that it introduces the concept of law of limitation in matters pertaining to contract. The section actually says no person shall be entitled to commence proceedings for any relief or remedy for breach of contract if 3 years has elapsed on the date of which the breach has committed from the date on which such person became aware of such breach, whichever is later. The burden of proving that person became aware of the breach of contract, not when such breach occurred, but a later date, shall be on the person who claims. So, looking at that section, it bars any claim from relief for a breach of contract, shifts the burden of this from no- on the non-breaching party from the breaching party. Okay, and the concept of law of limitations in matters pertaining to contract is particularly very new, and it is introduced under section 220. This section basically, bars persons claiming any form of relief for breach of contract if it has been 3 years since the breach has been committed or non-breaching party aware of the breach which is later. So this is interesting because, as I told you, if due to the COVID, uh, scenario, a party is not able to come to the court and claim their, or file for breaches, then they are barred from breaching their file. But there is a concept that we studied about which measure. So under that concept, definitely you can apply, in fact, this same doctrine and say that we had to delay the application to the court or filing a suit against the person because it took us a lot of time because of certain unavoidable circumstances which is beyond our control. So that court has to look into that and has to consider that aspect as well. So with this, we have come to the end of law of limitation and also law of remedies under the Contract Act. So with this, we come to the end of the uh, remedies under the contract law for this course. And so if you have from the recorded classes that we have, this one as well as we had the earlier classes on recorded classes. If you have any questions, if you have any comments, if you have any clarifications, note down those, and you could either send it to me by email or you could also post it directly on the Google Classroom under each of the lecture series. And then from next class, as you are aware, we will have a small group or a smaller class because the class has been divided into different groups to discuss and understand this concept in much detail. I will send some Buddhist case laws as well as few selected foreign case laws which will be used as a means to generate and discuss uh, in the class to understand this concept in much elaborate manner. I have provided the guidelines or the basic fundamentals of remedies under this lecture series, and also read the remedies chapter under the Smith's book. I have already sent you the uh, page numbers as well as the chapters, and I will also send probably one or two articles on the remedies so that you will understand this the concept of remedies in much more clearer. And I will see you in smaller group classes from next class. So with this, we have come to the end of this lecture series, and thank you to every one of you, and I will see you all in the next class in smaller group classes. Have a nice afternoon.